Hello, everyone, and welcome to today's webinar, What Will Happen in International Trade in 2023? I'm David Schwartz. I'm a partner in Thompson Hine's International Trade Group, and I'm also the group's practice group leader. I'm joined today by my colleagues, Francesca Guerrero, who's a partner in our International Trade Group, and Dan Ujczo, who's Senior Counsel in our International Trade Group. Before we begin, I must address a few housekeeping items. First, today's program is being recorded, and we'll send a link to all attendees within 48 hours of today's presentation. The presentation is intended for the general information of individuals and organizations on matters of current interest. The thoughts and opinions expressed today are those of the individual panel members only and do not necessarily reflect the opinions of the panel members' clients, employees, affiliates, or Thompson Hine. The content should not be taken as advice, as the views expressed are for informational purposes only. If you have any questions during the webinar, feel free to use the question box located in the control panel on the right side of your screen to submit questions. We'll answer as many of the questions as we can, both during the presentation itself and at the end of the webinar. If we don't get to your questions, we'll follow up after the program, either by email or by phone. We'll be offering CLE credit for today's webinar. Please be sure to complete the verification of attendance survey. A link to the survey is included in the agenda that can be found in the handouts section of the control panel located on the right-hand side of your screen. We will also paste the link in the chat at the end of the program. I will announce the tracking code at the end of the program, likely at the top of the next hour. In the handout panel, you can also download a copy of the PowerPoint slides as well as bios of today's speakers. Again, thank you for your interest, and let's get started. On our first slide, we present to you the topics that we plan to address in today's webinar. This is our agenda. If you see a topic that's not listed, please feel free to send us a question during the presentation, and we'll try to address it again, either at the end of the presentation or afterwards if we don't have time. Next slide, please. We're going to start off today's webinar with a topic that's probably impacted everybody who's on today's webinar, and that's the China Section 301 tariff. For the uninitiated, 4 to 5 years ago, the Trump administration initiated these tariffs on approximately $350 million worth of imports of Chinese goods. There was a product exclusion process that allowed many products to be excluded, roughly 6,800 total. But that product exclusion process ended about a year or two ago, and currently there is no product exclusion process in effect. Most exclusions have in fact expired. Certain ones still remain. There were ones that were provided for products that helped address the COVID-19 pandemic, and 81 of those 99 are still in effect and have been extended through the end of next month, through the end of February 2023. Also, there are more general exclusions that are still in effect, roughly 352 product exclusions that were scheduled to expire at the end of last year that have been extended through September 2023, when it's anticipated, next slide please, when it's anticipated that the USTR's current 4-year review of the China Section 301 tariffs process will end. If you all have been keeping track of this 4-year review, which is statutorily required, there was a comment period that ended very recently, 2 weeks ago, which received more than 1,500 responses on a variety of topics concerning the Section 301 tariff itself. There were a large number of folks, many domestic industry representatives, that filed comments pushing hard for the Section 301 tariffs to be continued. There were many importers and trade associations requesting that the Section 301 tariffs be terminated. Those same folks, those same companies, those same interests were also pushing for the reintroduction of a new product exclusion process. And interestingly, there were certain companies and domestic industries that were pushing for a reduction in the de minimis requirement from $800 to $200 because they were finding that there were individuals and companies that were able to escape the Section 301 tariff by importing product in very small amounts below the $800 de minimis requirement. All these comments that the USTR will be considering in its review will likely lead to a draw. There's enough people that are lining up for the tariffs and enough people lining up against the tariffs. And the US government has a strong enough interest in seeing the tariff continue that it's highly unlikely that the tariff will be terminated. It's likely that the tariff will be continued and that a new product exclusion process will be reinstituted. I think for now, the tariffs have become the status quo. It's been built into people's business plans. And the US government, now the Biden administration, finds, like the Trump administration before it, that these tariffs are a useful negotiating chip with China. Next slide, please. Another important development that's occurred with the China Section 301 tariff is the tariff refund litigation that was brought in September 2020. It's been 2.5 years now. It involves thousands of companies. Chances are, if you're watching this, you're probably involved in some way. And it concerns whether or not the Trump administration timely instituted tariffs on products that appear on List 3 and 4A. The CIT came out with its initial decision last April and determined that the president did indeed have authority to assess these tariffs. But the CIT, three-judge panel, determined that the USTR did not follow the Administrative Procedure Act, the APA, because it failed to provide adequate responses and explanations to comments that were filed as part of the process. On remand to the USTR, the CIT instructed USTR to demonstrate that they in fact did provide adequate responses and explanations. There's been a lot of back and forth since the August 1st USTR response, and there will be a oral argument next week on February 7th about whether or not the USTR met its burden under the remand. We expect a decision from the CIT by the summer. I can't predict exactly what the CIT panel will do. I can just tell you what's within the realm of their options. They could vacate the tariffs, they could do another remand, or they could affirm. I can tell you this though, whatever decision the CIT does come up with, it will be appealed by the losing side to the US Court of Appeals for the Federal Circuit. And it's conceivable that even after the CAFC considers the appeal, that it could be appealed and even certified by the US Supreme Court because of the issues involved. The outcome for this litigation, all that I can tell you right now is that it's not going to end for a while. So don't start counting on your refunds just yet. Next slide, please. If you haven't already taken action in regard to the Section 301 tariffs to alleviate the pain of these tariffs, then it bears repeating what options are available to you. First, If you didn't take advantage of the product exclusion process when it was available, the first go around, if it returns and you want to alleviate the pain of that 25% tariff, then you should certainly take advantage of it if it's offered again. You should also consider shifting your supply chain away from any China-sourced product that's currently subject to the 25% tariff. You can also consider further manufacturing a China-sourced product in a third country so that the country of origin changes under the substantial transformation rules. And if you consider any of these options, I strongly encourage you to consult a lawyer first for the options that work best. We know of too many companies that have tried this on their own and have found out the hard way that they did not qualify for escaping the tariff through the options that they pursued. Next slide, please. Francesca?
Thanks, David. And before I start talking about forced labor, I just like to repeat that if you have any questions, you can send them to us like in the little question box on the panel on the right side, and we'll keep tabs on those and try to answer them during our sessions if we can, or at the end of this session when we have time for questions. So forced labor legal trends. I think many of us have been tracking forced labor for some time now, as all of these different acts that you see on the slide have been coming into force, coming into the news. You know, one thing I think that I just want to highlight here by showing this trajectory is that it's not stopping. There continue to be new rules, new requirements in place that, bottom line, are requiring companies to dig into their supply chains, understand the sourcing of their materials in a way that many industries didn't really have to do before. So when we talk about forced labor, you know, the way that the regulators look at it is anything that's made in whole or in part by forced labor. And that means that they're not just looking at your immediate suppliers. They're not just looking at like the manufacturers that you're buying from. They're looking down into the supply chain for any materials that are produced and supplied using forced labor. It's a little bit logical if you dig into the issue substantively. That's where forced labor is. It's really at the raw material level. So you know, it's nevertheless creating quite a burden for companies who have not necessarily had to have this much transparency in their supply chain. So I think one of the themes for 2023 will be grappling with how to get increased insight into your supply chains with respect to where your suppliers are sourcing their own inputs from, how to figure out how to allocate your resources towards the highest risk materials, how to sort of start building the blocks of a compliance program that will meet the needs not just of 2023, but forced labor compliance in the coming years. So we'll talk a good bit about Uyghur Forced Labor Prevention Act, which was signed in 2021. As you all know, it became effective last June 2022, and CBP has been just increasingly enforcing it. But we also will talk a little bit about just the broader forced labor trends. Next slide, please. You'll see here, and I use this slide to highlight that forced labor is not just an issue that focuses on Xinjiang and the Uyghur Forced Labor Prevention Act. We'll talk about that more in the next couple of slides, but there are withhold release orders around the world. There's, you know, a recent one in the Dominican Republic focused around sugar. I know many companies have been wrestling with palm oil issues in Southeast Asia. So it's not just China, although that is one of the highest risk areas. And next slide, please. one of the best places to figure out where you may have high risk materials is looking at the Department of Labor's list of goods like at high risk of forced labor, and they do it by country and by region. So you can perhaps get an indication that withhold release orders may be coming in these areas, or that you need to devote more scrutiny. But the biggest risk area for everyone is Xinjiang. And well, not for everyone. The biggest risk area for many, the most universal risk area is going to be goods with supply chains in Xinjiang. The Uyghur Forced Labor Prevention Act created a rebuttable presumption that any goods that have inputs from the Xinjiang region are made with forced labor. So when it's a rebuttable presumption, that means that technically companies can attempt to provide documentation to show that despite this presumption, they have done an exhaustive review of their supply chain. And in fact, the goods were not made with forced labor, even though they may have been made in that region. Now, we haven't seen anyone effectively rebut the presumption. Mostly what they do, and I think next slide will show this. Next, yeah. So mostly what they do is attempt to demonstrate their goods did not carry back to Xinjiang. However, recently CBP announced that they were reviewing their first two attempts to request an exception, which means rebut the presumption. And so I think that is something that we will see, that we'll look for in 2023. Is that plausible? And that's, you know, we don't know yet whether that will be effective, whether companies will be able to use this rebuttable presumption, but I think that is something that we will see develop in 2023 is, you know, understanding the metrics, the documentation required to, you know, effectively or not rebut the presumption. You'll see here that in order to submit this type of request, you have to explain your due diligence system, you have to have extensive documentation showing your supply chain tracing and additional supply chain measures. It's a very high standard. Next slide. What companies have been doing, and there have been, you know, items successfully released in 2022, and we'll continue to see this year the sort of standards develop, is people have been demonstrating that their goods are in fact out of scope of the Uyghur Forced Labor Prevention Act because they can chase the supply chain all the way back to something outside of Xinjiang. And this has various advantages, you know, process-wise. One of them is that you don't necessarily have to show an audit from factories in Xinjiang demonstrating a lack of, you know, forced labor. But, you know, these are two things that we'll keep looking at in 2023, seeing what the real sort of nuts and bolts of complying with the Uyghur Forced Labor Prevention Act are. Next slide, please. I expect that we will see the focus move to different industries. And we've seen a lot dealing with solar in the last year. We've seen a lot dealing with cotton and textiles because those were pre-existing WROs from Xinjiang, a lot dealing with tomato. What happens is that CBP investigates supply chains in order to identify who's likely to have, you know, raw materials from these sections. And it's a pretty fact-intensive process for CBP. So they do, much like other enforcement authorities, move from industry to industry as they get smarter. We don't entirely know which industries will be the spotlight, but many of you in the auto industry did see at the end of last year a report come out from think tank in the UK that was also instrumental in shining a spotlight on the solar industry in previous years. So I would not be surprised if in 2023 we do see some of that. Other industries that may, you know, focus include electronics. There's been significant talk about electronics industry. Next slide. So outside the United States, as I mentioned, we've got the Uyghur Forced Labor Prevention Act, but there are a number of other bills, proposals in the EU and Canada and other countries that would require disclosures related to forced labor, that would require affirmative due diligence be conducted, like they're creating due diligence standards that are, you know, banning imports of goods made with forced labor. And the EU forced labor proposal has sort of a unique focus on not just imports, but also any sort of, you know, use in commerce of the goods. So it would ban the goods. It, you know, conceivably could lead to things like recalls of products from shelves. So there's a lot happening, and I think that 2023 will be a year that companies are really grappling with, again, how do you investigate their supply chains, make sure that they are taking a risk-based approach to managing this legal and, you know, business risk. Anything, Dan, David, I think that's my last slide on forced labor that we want to add. Oh, you know, I have one thing I should add. March 18th, if you all haven't seen it, CBP is requiring postal codes for as part of the implementation of the UFLPA. So they're trying to zero in on where some of the materials are coming from within China. So I'm sure people are gearing up for that. But yes, anything else?
There are no questions, Francesca. You must have thoroughly covered the subject.
Or people don't quite know where to start. I think next slide, and that's
Yeah, okay, and I think again, I'm Dan Ujczo, and thanks again to David and Francesca and to everyone for joining, for your most precious resource, your time. And we started right out of the chute with China, and issues relating to the PRC or China are dominating, right? That's the legacy going back, you know, for a couple decades now, but certainly in this period of time, so many global trade compliance managers on the line, counsel, government officials, economic development folks, you know, there was that period of 2016 to 2020, which was just chaos, right, or crazy, where we were following trade policy by tweet. And then, of course, we had the COVID period, which really requires no other descriptive term other than to say that made 2016 to 2020 look calm. And to some extent, particularly for those of us that do trade and transportation. And I think our concern to some degree, and maybe we're lawyers and we worry too much, and that makes us awful people to be married to, but we're always worried about the risk. And of course, there's a sense of complacency, I think. And I think one of the things that David said, we came right out of the chute mid-January on the Section 301 tariffs. And of course, forced labor is something that was a large factor last year with all of the issues Francesca's talked about. But I think one of the concerns that we have is, I think within the C-suite in particular, is there's a little bit of complacency as other issues have dominated, or particularly economic issues. And so just to pause for a moment, and then we'll turn to USMCA and some of the more domestic looking issues that are impacted by all of these. The one thing that is while there may be China fatigue within corporate boardrooms, there's also a sense that now the language is going to change. And so if you're sitting here wondering how this all stitched together, number one is, of course, the focus over and over again is on inflation. And all of you in your businesses, or the overwhelming majority, have been told, you know, we have to cut costs, or we have to be in standstill mode until we figure out where this is all going. And there's a very real issue as we look at 2023. We know costs have to go up. David said it at the outset. These issues are baked into the tariffs and other things are baked into our costs now. And there's a real issue if the Fed's target is 2% inflation, is we're not going to get there. We're not going to get there largely because we may deal with the COVID supply chain disruptions. We may deal with other issues, right? I do all the grocery shopping. I pride myself on knowing the cost just in case of groceries, just in case I ever get on the prices right? And we know what's going on there. But the reality is that things just cost more now because we're in an era of ally shoring or friendshoring. We have 25% tariffs. And so as you're sitting there as a customs compliance manager, you're being asked to level out costs. How are we going to do that? And then how is the Fed going to react to that when we don't get to 2%? Similarly, we have and how do I know that? I'm not an economist, but if I could commend you to anything other than this webinar and our ongoing Smart Trade series, which are all free, by the way, but is to Google the costs of trade, Davos, and Ambassador Tai. Our United States trade representative sat on a panel at Davos and basically told the entire audience, it's worth watching, it's worth the half an hour of your time if you want to see what's coming in 2023, and said it was a masterful performance, whether you agree with it or not. The moderator was a little cringeworthy, just as a caution if you watch it. But she basically says, look, in the last minute, that the trade system was too efficient. The trade system that you all at Davos have espoused over the years had efficiency, but it sacrificed workers, and we are going to pay the premium. So there is a premium now in the U.S. official position that costs are going to go up, and part of that is worker-centric trade. That's the language we are using today in the U.S., and Francesca just discussed this at length, with forced labor issues being the bedrock of that. But as we'll see in USMCA, that once we start moving supply chains to places like Mexico, there's been no larger beneficiary than Mexico to the Section 301 tariffs. That part of USMCA also says we want more collective bargaining there, and through the rapid response labor enforcement mechanism that we'll talk about. And so that's a policy decision, that's a political decision too. But for you that are doing global trade or customs and trade every day and compliance, how many of you have looked at your customs compliance manual and say, I better have a link in my org chart to the HR department? Because if you're going to want one of those exclusions that David's talking about, if there's a new exclusion process, it's not going to be that it didn't work during the exclusion process, that it would cost us more money to make if we can't source from China. That was understood. You better be able to show how many jobs are being lost or how many jobs in your company are important. So looking at that from a whole of company perspective. And then of course, when our industrial policy here, all of the things that we're creating right here in Columbus, Ohio, that I'm sitting, where Intel has made major investments. Of course, if you're going to have that industrial policy, chips, the Inflation Reduction Act, you have to make sure that you have domestic preferences, or at least continental preferences, or ally shoring preferences, or else companies that may not meet trade agreements could say, hey, we could still bring that in from a third country and offset it with the tax credit. Right, so that's where Buy American and Buy America and Build America, Buy American, which we call BABA. And then of course, Francesca's mentioned solar. Our climate change policy in green shoring is the fact that we just don't make solar here except for cadmium telluride solar, which is made right here in Ohio. And so the Biden administration, in order to achieve its green energy goals or clean energy goals, we have to allow some of that to come in. At least that's been the policy choice, while stimulating domestic manufacturing. And so this isn't the language of tariffs anymore, and I think that gets lost in some of the media coverage of this and in boardrooms, but it's all the same issue that we've been dealing with since 2016. Now, to drill that down into specifics, to come out of the clouds a bit, next slide, please. One of the issues that David mentioned a moment ago is, how do we restructure our supply chains? The goal in the last administration was rebalancing trade. The goal in this administration is rebuild. Right, rebalance to rebuild, or build back better. So what we've seen as companies have moved out of China, or are attempting to a deal or work around the tariffs, is that we've seen more than 1,000 rulings. It's about almost 1,100 right now, coming out of U.S. Customs and Border Protection, who have to enforce this at the border. Behind the border policies, this is at the border decisions. And U.S. CBP very early on didn't really know what to do. They were kind of overwhelmed. But in 2019 and 2020, when they were ruling on a number of these issues and publicly disclosed those, that if it had the word China in it, it was going to be tough to bring it in. They were going to find a way to make sure that the 25% tariffs. But one of the most consistent threads that we're seeing is that Mexico and Vietnam tend to be a little bit easier unless it was steel or something in a very sensitive technology. Mexico, Vietnam, somewhat Taiwan, and then other areas of the Asia Pacific. Next slide. But one of the things that we're seeing now, and we track all of this internally, we're constantly monitoring the opinions and looking at the factors and keeping those. So as companies go and try to get advisory rulings or rulings from customs, that we know what are some of the buzzwords. But what we're seeing now in the COVID period, going into post-COVID, is that if the production starts in countries like Vietnam, Philippines, India, and then goes to China for final assembly, that seems to be passing the smell test. It will not be found to be a product of China, which that makes sense. That has fidelity to the whole concept of substantial transformation. that it's not where it's assembled, it's where it's manufactured, is the country of origin. But there are some catches. For example, we see a lot of opinions coming from US CBP about like hand tools, scissors, garden rakes, hose, those kind of things, things in basically my garage, essentially. But you have to ask yourself, it's like, well, those are initially molded in Vietnam and then sent to China for final assembly. Where's the steel coming from? And we know in the Asia Pacific, the steel is all coming from either China or Korea. But what you'll see is custom kind of glosses over that. US CBP will gloss over that and say steel from global sources. So there's an understanding, and all of this to say that there's an understanding as we attempt to deal with restructuring our supply chains, that US CBP seems to be a bit sympathetic, that as long as you're not putting all of the sensitive technology or having the whole supply chain in China first and then trying to do simple assembly in Vietnam or Mexico, but if you actually do try to restructure and do the final stage assembly in China, you're okay. And there's a focus on, as you can see in the second bucket, enabling technology. These cameras that we're talking into right now, a lot of US CBP rulings on these. But it's really what's deciding it is where's the PCBE, the technology, not where the lens, not where the plastic is. Where's that intelligent, that enabling technology? But areas where are just touch button issues, and Francesca talked around some in the forced labor context, anything to do with electric vehicles, batteries, automotive parts, good luck. Chemicals, pharmaceuticals, you can make the pharmaceuticals somewhere else and encapsulate those in China, and that's fine. But the actual ingredients, and of course, cannot come from China, critical minerals. So those are some of the trends lines we're seeing. So I say that because as you're looking for cost savings, just because it's from China doesn't necessarily mean it's going to be found to be a product of China subject to 301. You have to look at that entire supply chain and look at those structuring decisions. Now, in the final bit of time that I have here today, I'll talk a little bit, next slide, on USMCA. USMCA, according to Ambassador Tai and all members of Congress, is the bedrock foundation of US trade policy. I talked just a moment ago, one of the key differences between NAFTA to USMCA was the inclusion of the rapid response labor enforcement mechanism, meaning Mexico had a constitutional reform prior to USMCA that was just basically sitting on the shelf that encouraged more collective bargaining, was trying to get rid of company unions and encouraging real unions like we saw. It's akin to what we did in the 20s and 30s in the United States. And what the USMCA said, that's sitting on the shelf, you're going to implement that, Mexico. And so now the private sector, AFL-CIO, various unions in Mexico can go to companies, your operations in Mexico. And if they don't think there's fair collective bargaining going on, bring a claim to the US government. And the US government will then examine it in a very short period of time, usually about 45 days. And if they think there's a violation, we'll tell the Mexican government, we think you need to go fix this, and a process starts. This has been the most active area of USMCA right now. We just had one come last week. They're going company to company. But what's the key driver for 2023 right now is any collective bargaining in Mexico has to be called what's legitimization by April 30th. So by May 1st of 2023, all collective bargaining agreements have to go through a process where the union that's presently there says we want to keep, or the employees say we want to keep our current union in the agreement, or else it will be deemed invalid. And so you will see a lot of activity in Mexico over the next few months. And I flag this because if you have operations in Mexico and this is news to you, legitimization isn't something you haven't heard of before, it's time to start focusing on that right now, if not well past. Similarly, labor value content, and again, going back to the point that I made a moment ago, and then most of what USMCA has been about in the last couple of years have been the disputes between the governments. Dairy with Canada, energy sector in Mexico, and of course, we just had a major decision on the auto rules of origin. This is where Canada and Mexico have disagreed with the US interpretation that was going to make it more difficult for automakers to meet the USMCA's auto rules. We did an extensive client alert on this and would commend you to that. But the bottom line is that applies beyond the auto industry is Canada and Mexico and automakers said the rules that we agreed to in the agreement are the agreement. You can't put extra conditions on. And roll up. The concept that once a part reaches the threshold in USMCA, say 75% made in North America, or so let's say you hit that 75% at 78%, we don't care about the other 22% that isn't from North America. That is a 100% citizen of North America down the subsequent stages of production. And that's important for all of you that are structuring your supply chain. And we expect USTR, or excuse me, and USCBP have already signaled that we're going to see new guidance on USMCA come out here likely by the end of the first quarter, early second. Next slide, please, and then I'll wrap up. But USMCA,
Dan?
of course.
Dan, I'm sorry if I can interrupt. We have a question
Sure.
concerning the recent decision. According to our last client alert, we indicated that the U.S. could sidestep the USMCA panel on auto rules of origin by issuing, as you just said, different guidance to automakers and suppliers under the IRA and or under BABA. Can you elaborate and say specifically what recourse do Canadian manufacturers and suppliers have if the U.S. chooses that route?
Sure, and I mean, that's a perfect segue to where we're going. So if you could just bear with me for a moment, and then I'll directly answer that, is one of the things that's very important for folks to acknowledge or recognize is that USMCA sets the rules for North America. Now, parts are coming in from all over the world. If those parts are subject to the Section 301 tariffs or steel and aluminum tariffs or anti-dumping countervailing duty, you have to comply here with USMCA. Then the next tier is that you have to still do a substantial transformation analysis because to make sure that they're no longer a product of China. So a lot of companies have been skipping that step. So going to the question, so auto rules of origin, I met USMCA, but if it's subject to a Section 301, I still have to do a 301 tariff. And let me just park there for a minute before talking about the IRA, and then I'll quickly turn it over to Francesca. One of the most significant issues from NAFTA to USMCA was the certificate of origin, that piece of paper that you used to say this complies with NAFTA and pass to your customer or down the supply chain went from a noun to a verb. It's certification of origin. So you have to do the homework now. So you have to show that it meets USMCA. You now have to show that it meets the substantial transformation test. And then you pass that down to your customer. Now, one of the things that we're seeing right now is when USCBP or Canada Border Services Agency or SAT in Mexico are going and looking at your customer certificates of origin, they're saying, we want to see that you, the client, did the homework. And then let's say that you turn out to be wrong. There's now a contractual dispute between the customer and you. So it's a very important time to look at the T's and C's that you have. What's your obligation? Did you exercise reasonable care? Now, back to that question, next slide. USMCA, you've checked all the boxes, but now we have the Inflation Reduction Act. So the Inflation Reduction Act, as many of us know, is dealing with electric vehicles, solars, a number of areas. But the Inflation Reduction Act, we got some guidance at the end of December. We're expecting guidance by the end of March that defines what substantially all of the manufacturing or assembly activity is. And this is particularly important for electric batteries and battery production. Under US Treasury, not trade law, under US Treasury tax law, substantially all manufacturing or assembly means about 80%. That's how it's typically defined in the IRS code when you look at different examples. So to the question that was asked earlier, USMCA 75%, mostly for electric vehicles. Will the IRA make it 80%, in terms of the components? We could go on the rest of the day talking about the IRA, but the key 2023 point is we're going to get some guidance in March that's going to help us define these terms. And there will be a comment period that'll likely last until June. For you as a global trade manager, if you're out there, you have to now do USMCA or whatever FTA, substantial transformation analysis, and now look at the IRA. And the terms may be different. The standards, the regional value content may be different, and the valuation standards. And just last slide, and we'll get you teed up here, Francesca.
Yeah, and Dan, I was checking the question box. We have a couple about USMCA, just to clarify, if anyone asked real quick. Could you explain the proof of eligibility under the USMCA, like how that works with the certificate that has to be provided to a distributor, and sort of, if someone's a distributor and they require like a manufacturer to provide a certificate, what else do they have to provide to kind of demonstrate eligibility?
Sure. And that's the key. I mean, in the old days, people would just fill out the certificate of origin form and check some boxes. And we realized after about 30 years of doing that people were just filling out the form and actually not doing having the underlying documentation. So one of the things that we've done it's a couple thousand times now, is work with companies to go through and actually look at your products. Are they properly classified? Go through the USMCA analysis, give you that opinion, and you have all the underlying documents that support that certification of origin. And that needs to be done on an ongoing basis. If you change the formula, you change your suppliers, always making sure the USMCA is a living, breathing document. Those obligations are on the customers and all of us that are clients on the call, that to keep that on an updated basis and randomly sample and audit. Talk to your purchasing teams, talk to your sales teams. Has anything changed? And so when you pass those on, so what that also means in your contracts with your customers, you better be saying, hey, we exercised reasonable care, but if USCBP thinks we're wrong, who's on the hook for that, right? And let's work that risk sharing out, because it's often not a relationship between you as the client and the regulator, because you may be selling into Mexico where the distributor is. That importer of record's on the hook in Mexico, but they may come back to you for those fees. So you want to deal with that in a contractual way. And so ending up lastly, all of these issues are the scope of domestic manufacturing now is coming along with Buy American or Build America, Buy America issues. And we've included some slides here, but in the interest of time, I'll just skip to, so Buy American has been around since the 30s. This is largely for steel and iron. And there's long tests, but the most important point is that the thresholds that used to be 50% or were 60% by the end of the Trump administration are going to be 75% by the end of 2029. So you have to know, if you have steel and iron in your product and you're getting federal funding or state funding from the feds, you better make sure that you know exactly that's steel and aluminum, or steel and iron, excuse me. Next slide, please. What's greater significance is Build America, Buy American. This was part of the Infrastructure Act. And this isn't just roads and buildings anymore. This is broadband, telecom. Many solar companies are now under getting federal and state funds. And so all of these products are now subject to new Buy American rules. And these are different than what we've done in the past. And they're certainly different than the rules under USMCA, IRA, and elsewhere. And one of the most important of which is, if it's a manufactured product, not only does it have to be 60% made in the United States, the last two manufacturing steps have to be done here. So we could go on all day talking about the ins and outs in here. The purpose of this is to really point out to you all that are dealing with these issues that you're going to do USMCA. You're going to then do the substantial transformation if it's a China tariff. Then you have to look at the IRA if it's part of trying to claim an IRA tax credit, which may be different than those rules. Different bill of materials, different valuation analyses, et cetera. And then lastly, if it's part of the BABA, you may then have to say, geez, I still have to make sure the last two steps are manufactured in the United States. These are all different tests. And I spent almost 20 years of my life in government. We would hope that various agencies were working these out and organized. It doesn't work that way. Everybody has their own little piece of the puzzle. So the answer, David, that's a very long answer to the question, is yes, the US absolutely can address some of the things that it lost in auto rules by saying, the IRA standard's harder. Under the Inflation Reduction Act, or Buy America is more challenging. And so that's a little bit longer than we wanted to go for that session. And so I'll turn it back over to you, Francesca.
Thanks, Dan. And
I'm sorry, Francesca, if I can interrupt. We do have a question for you. Do you think that USTR will change its approach on autos to follow the panel decision, or do you think it will throw its weight around with Mexico and Canada to get them to accept some other resolution?
Well, one of the things that happens is after we have a lot of IP lawyers in our firm, and they don't let me show this picture, but we've all seen in social media the Spider-Man that are all in the circle ready to shoot each other with their webs. It's like a circular firing squad. That's what the USMCA disputes are right now. The US had the auto rules and it's lost, but it's going after Canada for dairy. We got energy with Mexico. So one of the things right now is all of these are interconnected, because the results will be if you're going to not implement dairy, then we're not going to implement autos, et cetera. So it's a piece of leverage. right now, particularly as we're in discussions in the other disputes under USMCA, as we're dealing with IRA, BABA, et cetera. So I think I think at the end of the day, the politics and policy will be that the auto rules will be implemented in accordance with the decision. It's not a question of if, it's a question of when. How long is it going to take the US to really implement those? Because in the economic environment we're in right now, I think making a change like that to the auto industry isn't exactly great politics here in Ohio, and that state north of Ohio that has Detroit in it. I'm a Buckeye, so we don't say the name of that state, but et cetera, et cetera. So I think it really will occur. USTR will comply. It's just a question of when and getting what in return for it.
Thanks, Dan. Sorry about that, Francesca. Please proceed.
Oh, thanks. Next slide. And I think we're trying to organize our points thematically. So here we're segueing from the emphasis on investment in the United States to potential restrictions on investment out of the United States. But first we'll talk about CFIUS and traditional FDI. So CFIUS process traditionally has been focused on inbound investment. And that's their statutory authority. I shouldn't say traditionally focused. That's the scope of their statutory authority right now. And as you all know, it's been increasingly active, scrutinizing different deals, especially those dealing with data and privacy issues and sort of access to information. So in October 2022, what we saw was enforcement and penalty guidelines. And that was the first time we'd really seen that sort of guidance from CFIUS. I think it ties back to the fact that there have been, a greatly increased use of mitigation measures for approval of inbound investment. And a lot of these are tied to, a lot of the most complex are tied to ongoing management of data, access to data, access to personal information. So what we've learned is that complying with that sounds easy when you're signing the agreement, but in fact it's challenging, and there's even with good intentions, many footfalls. So we expect to see this year continued focus on enforcing these mitigation measures and really trying to make the point that they don't go away. It's not something you agree to, and no one continues to monitor it. Next slide, please. But sort of more interesting topic, I think, is that there is a lot of discussion about our first outbound foreign investment restrictions. And as I was saying, Dan was talking about the emphasis on investing in the United States. There's also an emphasis on restricting investment outside the United States that might harm our national security. And we don't really know what this will look like. We know that there's bills that have been proposed, including one in the National Critical Capabilities Defense Act that would create sort of an outbound CFIUS screening mechanism. We know that this issue has bipartisan support. We've also seen now, Axios was the first to report it, but there have been a couple articles the last couple of days talking about a potential executive order that would preempt these bills and restrict investment to China. My crystal ball tells me that we will see something this year. I don't know exactly what it will look like, but based on reports and based on the sort of way we've been talking about national security lately, I think it will be focused on certain technologies. It'll be focused on certain technologies based on sort of their export control classification. And so it'll be fairly narrowly tailored. And I do think whether or not the executive order names China, I think that the focus will be outbound investment into China, into these technologies. So what does that mean? Let's see, is our next slide? we can go back one. What it means is that if you are, if you're a company that is investing in overseas businesses, that has sort of a, you know, corporate ventures group, or if you're an you know, private equity investor and others, the scrutiny of your investments is going to just continue to get increasingly complicated. And so you're going to have to do an analysis early on as to what these sort of trade restrictions might be that apply to your investment. That's kind of the bottom line. Increasingly, understanding trade restrictions early on in a transaction will help you be efficient and know whether these things are going to go forward. Next slide. Sorry, David, you look like you wanted to, did you have a question or no?
No, I don't. Sounds great. Keep going.
So another key point that we expect to see in the coming year is, you know, increased, again, focus on China and national security through the use of stronger export controls. So last year we saw, last fall, we saw these new rules related to semiconductor chips and advanced computing technology. They were mostly noteworthy for expanding the foreign direct product rule, which means that things made overseas that are the product of US technology are also subject to US export controls. They were also noteworthy for affecting services, which is unusual for export controls, so US persons providing services in these areas. We've already seen them extended. They added Macau and this month. We've got comment closing today on these export controls, so we expect that they will be refined in the coming months, and you know, we'll continue to see this balance. I think the struggle over this balance of wanting to support U.S. industry selling products into China against this, I think, increasingly winning strategy of focusing on investment in the United States and with allies, and you know, trying to restrict that sort of activity. So I think we will see more restrictions, essentially, on exports to China, but I do think it'll be mostly narrowly focused in certain industries, certain technology industries. Next slide. You know, again, the sort of attempt to be surgical means that we'll see more Chinese companies added to the entity list. We'll see a lot of enforcement. We've already seen it on sharing of technology and other exports with Chinese companies in the entity list. And next slide. I think, again, sort of the bottom line is that it continues to get more complicated to understand how you're supposed to comply with the rules of doing business with China. And companies will be focusing more resources on understanding their technology, understanding the export classifications of their goods, understanding where they have continued opportunities with China and where realistically they just have to scale back. And I think that's kind of it for China export controls. I don't believe we have a next slide, but we can try.
The next slide is for me. Thanks, Francesca. Well, I feel like we've done a bait and switch on you all because we promised you a discussion about Biden and Biden administration and FTAs. And as Dan hinted in his presentation, we're not really focused on FTAs in the Biden administration. We're focused on worker-centric policies, both at home and abroad, and at lessening U.S. economic dependence on China. The Biden administration has made it clear in a number of speeches just last week that it wants to move beyond traditional free trade agreements. And when I mean free trade agreements, I'm talking about those that have to be passed legislatively to provide market access and to lower tariffs. What the Biden administration wants to do in its trade negotiations and its trade talks is focus on values, a new global code of conduct, worker rights, better labor conditions, environmental standards, anti-corruption, a stable business investment climate, national security concerns, resilient supply chains, anything that makes the work conditions for folks in the United States and in other countries better off. This approach is in keeping with the Biden administration's focus on strengthening U.S. manufacturing, innovation, competitiveness through reshoring and friendshoring. And we want our trade partners to do the same and share the same values. Next slide, please. So what does this mean in practice? If we're focusing on worker-centric policies and we're not focusing on traditional FTAs, well, it means no further FTA discussions that were launched during the Trump administration with the EU, UK, and Kenya. That doesn't mean we're not having trade discussions with the EU, UK, and Kenya. We're just having these newfangled discussions that focus on worker-centric policies. It also means that because we're not focusing on changing tariffs or opening up markets, that we don't have to do it legislatively, which means we don't need trade promotion authority, which expired in July 2021. All these steps that the Biden administration wants to take in their trade talks can be done through executive agreement. The bottom line is, don't expect any traditional free trade agreements addressing market access or lower tariff barriers in the next 2 years. Next slide. That doesn't mean talks and negotiations aren't happening. A lot is happening. In fact, a lot's taken place in just the last couple of months. The Biden administration is focused on certain regions. They want to re-engage with these parts of the world. And they also want to put in place steps that will help them in their fight with China in establishing economic independence from our dependence on sourced materials from China. So you see now that we've started talks on the India-Pacific Economic Framework. We've entered into a memorandum of understanding with the free trade area covering Africa, the African Continental Free Trade Area. We've established the Trade and Technology Council with the EU. Just last Friday, we had the initial ministerial for APEP, the America's Partnership for Economic Prosperity. We've launched this month, a couple weeks ago, the U.S.-Taiwan Initiative on 21st Century Trade. And we're also, again, focused on trying to wean ourselves off of our dependence on Chinese product. We've established the Mineral Security Partnership with some of the larger countries with the largest economies in the world to ensure secure, diversified critical minerals supply chain that steers us away from China and that emphasizes ESG principles. All these steps are being taken to ensure that the U.S. remains engaged with these regions and these countries on economic issues. As we all know, TPP was passed, the third day of the Trump administration. We withdrew from it. And we're now trying to re-engage with that part of the world and with other parts of the world to establish a negotiating framework where we are available to talk trade. There's a hope that once these framework discussions occur, once these dialogues occur, that eventually it could lead to more traditional free trade agreements. We are catching up with all that China has done with its Belt and Road Initiative around the world. And these are some of the steps that we're taking to remain engaged on trade issues and remain engaged in opening up trade dialogues with countries that are already engaged with China.
David, there a couple of questions came in, if you want me to throw them out real quick.
Sure.
One person was asking if there's an update on the Boeing Airbus dispute, if that got rolled into TTC, and also a question about whether there's any hope for GSP renewal.
I'll answer the last one first. There is optimism that both GSP and MTB will be included in any trade bill that is introduced. The question remains whether any trade bill will get passed. But there is, I think, bipartisan interest in a bill being introduced that will include not only GSP and MTB. I'm not aware of a resolution to the Boeing dispute being addressed as part of the TTC. Well, we've reached the top of the hour. We're going to continue on. If you have any questions, we'll open up our formal question and answer session. But I must, at this time, because we promised you we'd be done in an hour, I must tell you, if you are seeking CLE, we want to provide you at this time the tracking code, which is TH80WT. Again, that tracking code is TH80WT. Do we have any other questions?
We do have
Francesca,
a
Dan?
bunch. And would you like me to go to the top and kind of scroll through ones we missed?
Please do.
We did have a question back on forced labor. I can address that, sort of asking about how likely luxury vinyl tile or auto parts from China will be subject to UFLPA detentions after the Sheffield University reports. So I don't think I can really predict how likely that is, but I can say that the earlier reports were cited in UFLPA guidance released by CBP. So we know they read them closely. And the one they cited was cotton, which we saw be the subject of a WRO from Xinjiang. We also know that the reports have led to congressional inquiries, like being sent to some of these companies. So we know that these NGO reports do get attention. And the fact gathering process around forced labor is, like I said, very intense. So the regulators can lean on this as a place to start. I don't know if anyone else wants to add anything on that point, but we did have kind of a question. This is a big picture question, Dan, and I think I'll boil it down to, if the U.S. government wants us to onshore and nearshore so much production, do we think heavy industry is really going to be able to keep up and produce all of the steel, aluminum, and other materials necessary for that sort of production? And is that a discussion that's really being had around the same time as the nearshoring discussion?
I think it's a great question, and I think it gets to the heart of the policy, right? Is the policy prescription and the politics. Look, the politics are trending in this direction, if not all the way there, that we want to support domestic manufacturing. For years, we would go down to I'm an Ohio guy, right? So we'd go down to the trade associations and the think tanks in DC, and the line was always, if we could show the American people how trade works and they'd understand trade, everything would be wonderful. And I think people saw in COVID what supply chains look like. And when they went to their grocery stores and couldn't get toilet paper and certain products, they said, well, wait a minute, what's going on here? And so I think that now the pendulum has swung the other way. And so there's going to be an equilibrium point. And I think that's where there is some opportunity for growth. I think when we look at how the Section 301 tariffs have over time, the interpretations of those, if there is an exclusion process that's effective, if you look at potential guidance around if USMCA can be effective, I don't necessarily think there's a distinction between heavy industries and others. The reality is how much steel can we produce, how much others. And so I think what you'll see is hopefully a rationing out of on some of these issues, or a rationalization or becoming more rational of issues that we've been dealing with since about 2016, right? We're starting to see more common sense apply. But I just think when you layer on now forced labor, IRA, BABA, everything else, it's going to take that same time. So hopefully at some horizon we can get to a point of rationalization. I think the key though is, just to echo the point that I said earlier, or repeat the point, that if there's any complacency that things are going to go back to normal, particularly in the C-suite, if things are going to go back to normal and they think that means pre-COVID, pre-2016, you're just not paying attention. I mean, the reality is that we need not complacency. What you really need is comprehensive compliance on these issues, on all of these issues, because the hits are going to keep coming, and really just remain vigilant. And that's particularly true in the C-suite. C-suite
Yeah.
care in 2016, 2017, 2018, when all of a sudden things went up 25%. And then COVID, but now it's like, hey, we got to deal with inflation right now. Well, inflation is part of this. This is part of inflation.
Yeah,
so I think that's where there needs to be a focus.
And Dan, I just wanted to build on something you were saying about the need for comprehensive compliance. I think what you're really saying, and I agree with, is that it goes beyond compliance. It's a strategic, it's a comprehensive strategic issue. Some of these questions, it's not really a matter of compliance. It's a matter of how do you maximize your capabilities, with all of these different factors out there. Which leads me to another question, and I'll just keep asking questions because I've got the box open if you want to. Is just quickly, Dan, could you repeat the 4 steps that you said, ending with BABA? You're like, when people need to think about things, it starts with USMCA and goes to this and this. So I was asking you to repeat that.
Yeah, I just think about this. If I'm a compliance manager and I have a product that I want to come in tariff-free, right, from a third country, or components are coming in, and I want to claim USMCA preferences, does it meet USMCA thresholds? Well, was it subject to China tariffs? Because if it was, even if it meets USMCA, I have to do a whole nother test, number 2, substantial transformation. And then I have to ask myself, is it subject, and are we trying to claim the Inflation Reduction Act tax credits? Or is my customer going to try to claim those? And those rules are still being developed as we speak. And then lastly, are these products and potentially my customer? Largely, you got to think of who is your customer. Is your customer going to be subject to Buy America, Build America, Buy America? And so BABA, so are they getting infrastructure funding for this? And that list is, as we're letting the spigots open and funding more projects, I mean, that's moving the economy in a lot of ways. There's more strings attached. So now I have to do the BABA analysis. So it's USMCA, substantial transformation, IRA, and BABA, among others. But those are the 4 main ones that I would look at if I'm bringing something to try to call it, necessarily an American made or North American made product. That's tricky. I mean, and particularly since 2 of those are major moving parts right now.
Yeah, thanks. David, I have one question here. It looks like a good closeout question, unless you have any to add.
Please proceed. I'm having a hard time opening up the question box. I'm glad
me too.
you have easy access to
it. So we got the question, which I think can close us out. It's, how might all this change with the 2024 elections? That's a big one. But I will say that with respect to the subjects I was talking about, forced labor, China, export controls, FDI, I actually foresee little change, except perhaps some competition between the parties about who can be tougher on China or who can talk tougher on China. But those are really bipartisan issues that have a lot of agreement, at least, and within the political ranks.
I would agree with you, Francesca. I think there is now bipartisan agreement that our trade policy's focal point involves China, and it's going to be that way for the foreseeable future. And you're right. The parties are probably just going to huff and puff about which party is tougher on China. But China, for the foreseeable future, will be the focal point, and all trade issues must be viewed through that lens. Do we have any other questions? If not, if you could go back 1 slide. I want to encourage everyone to visit our blog at thompson-hine-smarttrade.com. If you're not currently receiving our updates and invitations, you can go to this website and register to receive our mailings under the Publications tab. We update our blog regularly. There's usually updates every couple days. So if you want to stay current on all these topics that we've been discussing, please subscribe to the blog or visit the website at your convenience. We want to thank everybody for attending today's webinar. Please stay in touch. Enjoy the rest of your day. Be well.